Hello, everyone. Welcome. My name is Archie Piatti, and I work at Tahirih Justice Center. I'm here to help talk with you about the new executive orders. I want to welcome you to this afternoon's webinar. I'm joined by Kirsten Phelps as well, who is managing attorney in our DC area office, and I am the National Director of Policy and Programs for Tahirih Justice Center. So thank you so much for joining. I think most of you are joining us because you are a pro bono attorney who has taken cases with us, and so you are somewhat familiar at least with our work and what we do. We are going to go ahead and get started. What I'll do now is just walk you through a little bit what Tahirih Justice Center does, and then we'll dive right into the agenda and move through the executive orders and their practical impacts on our clients. So first of all, the Tahirih Justice Center, just to let you know, is right now the only national organization that has offices in multiple cities where we're able to provide direct legal representation to immigrant women and girls. We also very uniquely have a policy arm located here in the DC area. And here we are working very hard to make sure that the laws that exist and the policies that exist to implement them are the best they possibly can be to ensure the rights of women and girls who are seeking violence, immigrant women and girls seeking violence, fleeing violence. We have served in the last 20 years more than 20,000 clients, and our offices are in 4 cities, the DC area, Baltimore, Houston, and the Bay Area. As you know, as members of our pro bono network, our network is thousands of attorneys wide at this point across the country, and we couldn't do what we've done to serve immigrant women and girls without you, and so we're so grateful to have you as a part of our network and excited to continue to partner with you as we triage some pretty rapidly changing, landscape facing immigrants in America today. So for today's agenda, what we're going to cover are the most recent executive orders that came out on January 25th and January 27th. What I'll do is just give you a very brief overview of them. They are filled with many different policy changes that may have an impact on women and girls, on immigrants in general. But what I'll focus on today are really the highlights that I think are most likely to have the greatest impact and the soonest. And then we'll go from that into a brief summary of some of the ongoing litigation and advocacy that we're undertaking here at Tahirih. And then I'm going to make sure to leave a good chunk of time toward the end of the presentation for Kirsten, who is on the ground every day, representing clients and also managing a number of attorneys and a large caseload here in our DC area office, to share some practical advice and tips for you as you continue to work with your clients and Tahirih. Now, I want to be sure you know that although you are all in listening mode as just participants in the webinar, you can use the chat feature here to ask questions. Kirsten is reading the questions and we'll be responding either orally or via chat, and we will, when it's her moment to kind of give feedback toward the end, she'll also be addressing questions then. But do feel free throughout the presentation to go ahead and send your questions in, and we'll get back to you as we go along and at the end. All right, now if we can move the slide forward, thank you. Just to give you a brief preface, now before we dive into the orders, I think it's important to know a little bit of context, right? So what we need to remember is that the orders that have come out, these 3 orders, have resulted in significant chaos across the immigration system. We've been here on the ground talking with members of the administration, specifically members of in the agencies, Department of Homeland Security, Department of State, Department of Justice, across the country and here at headquarters. And what's hard for all of us right now as practicing immigration attorneys is that we don't know really what the answers are to many of our questions, and our allies and friends inside the agencies also don't know. And so these orders came out very quickly. They came without a lot of consultation, it seems, with the agencies themselves, and so implementing the orders has been very confusing for all of us, of course, as advocates, and certainly has had a not only confusing but also a very negative impact on many immigrants in the country who are wondering right now what is the likelihood of them succeeding in their existing cases, whether they should even bother trying to file applications, whether they are going to be arrested, detained, or deported. The questions are the name of the game right now. So what I'm going to do as I do this overview is offer you some thoughts and some predictions and some reflections, but please know that we will continue to update you with additional webinars and information as we have more information about what real implementation on the ground is going to look like. I also want to share with you that although some of the provisions did become effective immediately, and of course those have gotten the most news in the last few days, last 2 weeks really, we do know that other parts of the orders are going to take a fair bit of additional policy making, whether that be through other memoranda and other issued policies through the Department of Homeland Security or the other agencies, or possibly even regulations and rulemaking, which may allow for comment periods by the public as well, or finally through legislation and the appropriations process. And so there are a lot of things involved in these orders that may not happen at all, certainly because litigation is ongoing, and because there may not be funding, there may not in the end be the ability to create the infrastructures to make them even reality. On the other hand, so much of what's in these orders can be done right away, and so we are going to focus today on those things that we think are most likely to happen right away. So if we can go to the next slide, please. The executive orders that we're talking about are primarily, I want to be sure to just name them so we're not sort of guessing at which ones we're talking about. There are two that were signed by President Trump on January 25th, 2017. One about border security and immigration enforcement, and the other entitled Enhancing Public Safety in the Interior of the United States. And then a couple days later on the 27th, which I believe was a Friday, President Trump signed Protecting the Nation from Foreign Terrorist Entry into the United States. These three orders, we have done at Tahirih an analysis, a written analysis about these orders and what impact there might be. And that is available on our website. It also was sent out to participants ahead of this. And we can certainly make that available to you if you need it again. We do go through those memos, those orders, a bit more detail in the memo. So I would encourage you to take a look at that if you're looking for more kind of section by section analysis. If we go to the next slide. What I'm going to do here is kind of talk, instead of breaking down each memo, what I'll do is give you a sense of the sort of major categories of changes that we see. So one big category of change that's included in the executive orders is are changes to priorities for removal. So what we're talking about are when ICE, when Immigration and Customs Enforcement uses its staff, its resources, its time and money and energy to decide which immigrants in the United States it should pick up and raise, or pick up from jails, or take to pick up when they are filing their applications and they have failed, and then take them through the process of removing them out of the United States and to their home country. We are talking about the priorities for removal. These priorities shift from year to year, sometimes inside and even during one administration you may see different iterations of priorities. We certainly saw that during the Obama administration. The priorities shifted a few times, and so it is not unusual for priorities for removal to change. That in and of itself is not so surprising. Here what we note in this slide are some of the changes that are the most dramatic and most concerning for us. As you'll see, I've listed here in this first slide the criminal grounds which could make an individual a high priority for removal by the government. They include being convicted of any criminal offense, being charged with any criminal offense where not resolved, having committed any acts that constitute a chargeable criminal offense, fraud or willful misrepresentation, having abused any public benefits program, having been subject to a final order of removal, or in the judgment of an immigration officer, you might be considered a high priority for removal. And so I want to just say for a minute, this is a dramatic shift from what we have seen in recent years, certainly, but in my years of practicing, I have never seen any kinds of grounds for prioritization that are this broad and far-reaching. I want to point out that certainly being convicted of a criminal offense and certainly a grave crime might be one that would make somebody a priority, including violent crimes in the past have been considered priorities. But here we're talking about any criminal offense. We're also talking about a charge. Now, the reason why I want to highlight this is that certainly, I might be charged with a criminal offense, but until it's resolved, we don't know if the charge is valid or if there's ground. We're innocent until proven guilty. But in this situation, not only is there that kind of legal question, where there are survivors of domestic violence, sexual assault and trafficking, we have an especially heightened concern here when we're talking about charges. For example, I have worked in the past with a woman who was in self-defense, was pushing her abuser away from her and put her hands on him, right? He was being violent with her. When the police were called by a neighbor so that to come to the house and break up the altercation, presumably to protect her from her violent spouse, it was in that case, she said, the police said, what happened? And she said, well, he was abusing me and this is what he was doing and he was hitting me, etc. So the police said, okay, and then they turned to him and he said, well, she pushed me. And so the police charged both sides with assault, and then both sides were, had to live with these criminal charges until there was a resolution. If a woman, if a survivor of domestic and gender-based violence calls the police or has the police get involved based on charges, and she is charged, her attempts to seek protection for herself could be thwarted and put her in a very dangerous circumstance where she could be deported or put through removal simply because she reached out for help to get protection from ongoing violence.
Archie, we have a really great question just to clarify. When we're talking about these changes to priorities for removal, does this apply to any immigrants or only to individuals from the 7 banned countries list?
It's a great question. Thank you, Kirsten, for raising it, and to the participant who asked the question. So in this moment, I haven't even gotten to the order that talks about the 7-country ban, and so I actually purposely put that at the end because I think we're getting so much, that particular order is getting so much attention that I'd like to actually focus on some of the other orders right now. So the answer to your question is no, these priorities apply to all immigrants from all over the world, no matter what the reason is they are in this country, whether a person who is holding a visa, not holding a visa, who is here with an ongoing application, such as an asylum application or not. None of that is specified in the executive order. So we have no prioritization, essentially, even among these categories. All we know is that any immigrant in the U.S. right now who's charged with any criminal offense could be considered a high priority for removal. Committing acts, obviously, many of us commit acts that could be chargeable offenses, or we have at some point in our life, and it would be ridiculous to assume an entire family could be torn apart, or a woman could be sent back to violence and persecution, or she would become ineligible for application for protection because of simply committing an act if she was never actually charged with something like that. And then the list goes on. We've just talked about it, but of course, being subject to a final order of removal is one last one I want to lift up, simply because when an order becomes final, might be at the conclusion of removal proceedings, and then the conclusion of an appeal to the Board of Immigration Appeals. But a final order of removal, in my view, may be called that as legally speaking, but until you complete your appeals, which may be available to you through the federal circuit courts and even possibly the Supreme Court, really you have no business being taken anywhere. And so it would be a grave concern, really, if any of our clients were to be removed or made a high priority for removal prior to the exhaustion of all those appeals and possible remedies. If we go to the next slide, I'd like to talk briefly about some other changes to priorities for removal. Briefly, the orders contain a requirement that detention of anyone apprehended for violations of immigration law pending the outcome of removal proceedings could result in removal. Well, you'd have to be detained and then could be removed, certainly. And that is very concerning. In addition to the other slides, which really addressed criminal issues, this one is talking about a violation of immigration law, which is not necessarily always criminal. In fact, for the most part, violating immigration law could be something like overstaying your visa, and we really don't know right now whether those categories of individuals would be considered high priorities for detention and eventually removal. Another piece is that the last point on this slide is that detention and removal of anyone whose application to stay in the U.S. has been rejected is also called for in the orders. And so we don't know right now who that will apply to. It could apply to somebody whose case has been filed only in immigration court, like someone who came to the border and filed an application for asylum and was being adjudicated in immigration court. But it could also apply, there's not enough clarity in the orders to understand whether this could apply to somebody who has filed a paper application for a U visa, a VAWA, asylum affirmatively, or anything else where they would not typically necessarily be put into detention, or certainly, and not into even removal proceedings in many of those cases. So I'm going to move on from changes to priorities for removal. Let me just check if there are any additional questions that need to be addressed.
I had one quick question about, in the chat function, about individuals who have been granted withholding but are still checking in with ICE and whether we know if they're at increased risk for removal.
Right. It's a great question. I think right now the answer is we don't know. What we can say is that for all intents and purposes, we are receiving no information that leads us to believe that things are not business as usual for the very short moment. Certainly, complying with ICE requirements that are already in existence would be, in my view, the best way to advise a client for now. If that should change, of course, we would be letting all attorneys and clients know that. But for now, we definitely want to continue to comply with whatever requirements are already in existence. But yes, withholding category individuals are going to be certainly at risk of removal. We just need to keep an eye on when that might change. So moving on, then looking at intermingling of law enforcement with ICE. So one area that we have seen enforcement grow in the last few years in general has been around the whether local law enforcement, meaning your cops, your sheriffs, whether they should be deputized and really be enforcing the immigration laws. There's so many reasons why this is a bad idea. One reason that's sort of more, kind of what people talk about at the policy level certainly involves the fact that, immigration law is sometimes compared with tax law in its density and complexity. Then you have cops whose job is not to necessarily be trained in all of that, but certainly to keep communities safe, and they cannot possibly do that if they are also looking for people who are high priorities for deportation. So we are concerned about that just as immigrant advocates, but in the context of working with women and children specifically who are victims of gender-based violence, the idea that a woman would ever pick up the phone and call 911 when she is being attacked or abused goes right out the window if we say that if she calls the cops and a police officer comes to her door, he could ask her for her immigration status and then potentially take her to be detained and deported. If she has U.S. citizen children, if she is afraid of persecution back home, it's very unlikely that she's going to pick up the phone and call 911. So we, in fact, are leaving, by commingling, in fact, local law enforcement with immigration and customs enforcement activities, we are making communities much less safe. I think it's important to note that we're not just talking about immigrant communities. Of course, that is important, but we also 70% of our clients have experienced violence right here in the United States, and many of those abusers and attackers are U.S. citizens. So we're concerned about violent criminals who are abusing immigrant women but are also released into our communities. So we need to be sure that this doesn't happen. That's something we're very worried about as client advocates and as policy advocates. Some of the orders in various places condemn and defund so-called sanctuary cities, reinstitute the Secure Communities Program, invigorate 287G policies, and call for the prosecution of immigration offenses and place those at a high priority, any cases like that that are coming across the southern border. Very briefly, I know the sanctuary cities term has been thrown around a lot in media over the last year and a half or so, and has come back up again in the context of this campaign and now in these orders. It bears repeating that this term is really a false term. We're doing a lot of advocacy on this issue, and I think I could explain and discuss quite a bit more about what exactly are so-called sanctuary cities and what these programs could do to our communities. But in the interest of time and in the interest of making sure that you have as much practical information as possible, I don't want to, kind of go off on my policy soapbox. What I'll do instead is move along here and simply repeat that we need to be careful when we're working with our clients to remember that the fear that they have now, whether it has been made policy or not, that calling 911 could mean deportation. That's a very real fear for our clients at this moment because of the language and the message of the campaign and what is actually being called for in these orders. So when Kirsten takes over the presentation in a bit and does address more in-depth practical implications for counseling your clients, we'll address this a bit more deeply. If we move to the next slide, we look at border and asylum changes. It's a big category of change that happened in the orders. One of the big pieces of this is that there's a planned increase in detention now along the southern border, in the detention centers. This obviously is going to cost a lot of money and require hiring and bringing additional staff and building. And we saw since 2014 a sudden increase in detention along the southern border under President Obama in response to the influx of who turn out to be essentially refugees coming from the Northern Triangle countries, which are El Salvador, Guatemala, and Honduras, where, I might add, it is one of the that area is one of the most dangerous areas in the world to be a woman. For women and children who are fleeing that area coming into the United States, they have encountered detention at the southern border in greater numbers over the last several years. Tahirih was among a number of other advocates to try to fight against this notion of detaining survivors, women and children, either separately or in what has been called family detention, essentially jailing moms with their kids. We fought to end that. We were not successful. That practice does continue to exist. However, we did manage to keep it into at least a few weeks of time, simply a few weeks of time with the parole opportunity after that. What this order calls for is a real increase in the number of detention centers, the duration of detention, and the officers at the border who will be processing the cases. So we are going to see some real, I think a real drop-off in the opportunity for women who otherwise, and children who otherwise would qualify for protection under our laws. I think we'll see many more of them either being turned away, being discouraged from coming to get protection, coming into the country and giving up part of the way into their claims because of the inhumane conditions of detention necessarily at the border. And I say necessarily because in my view, and I think the view of many other organizations and those of us who work with survivors who've come into the United States seeking protection, putting them in jail when they've come here to ask for help is not a way to, it is re-traumatizing, and it is not a way to treat somebody who is a refugee asking for protection. So again, I mentioned the increase in detention. The detention for duration of all cases, so parole, we know, is called, there's actually a call to end parole. I put here a parenthetical, it could impact family members because the way the executive order is written is, again, very vague. It does say that the order calls for a drop in the abuse of the parole system, but it does not indicate clearly whether this is talking about women entering at the southern border and being detained and then being paroled into their communities where they might be able to access mental health care and legal counsel. Instead, it simply says an end to parole. And I want to be clear that parole is a word that is used in many contexts in immigration law. Also, where we are talking about U visa applicants, for example, who are on a long wait list may have the opportunity of seeking parole so that some of their derivatives, like children who are overseas and are in danger, could come and join them. So we don't know right now where parole is going to be stopped. Is it going to be stopped at the border? Is it going to be stopped in general? That remains to be seen. Again, detention, when it lasts for a long time, it's detrimental to a person's mental and physical health, whether an adult or a child, but certainly for children it's especially problematic. But when we see gender-based asylum cases in particular are the ones being filed at the southern border, and they tend to be the most complex and take years of litigation, including through BIA and federal appeals, BIA being Board of Immigration Appeals, and through the federal courts. We're very concerned about how long a woman would be detained. Would she be detained through her initial proceeding only or through the exhaustion of all of her appeals? Access to counsel in detention centers is hugely difficult. If any of you have represented a detained client or have gone and done a pro bono screening a day at a detention center, you'll know that for the people who are held in detention centers, there really is no ability for them to be able to it's very difficult for them to be able to make phone calls outside. They don't know what is free, what costs money. They wouldn't have a sense from inside the detention center of how to go about searching for an attorney. It is really a confusing process, and most attorneys find it very difficult to reach these detention centers, which are far-flung and difficult to get to. And so putting people for the duration of their cases into detention centers pretty much means that they will not be able to have a lawyer at their disposal. I don't mean to say anything negative about all the attorneys across the country who have given tons of time and energy toward pro bono representation of detained individuals. Certainly that is a heroic task that has been already taken on. But if we're talking about detaining all southern border crossers and applicants in detention centers for the duration of their cases, I think we have to assume there's no way for us to keep up with that demand as a legal profession. And so release out of the jails would be the only way for us to be able to provide adequate counsel. Ability to prepare for litigation, really means, if you've worked on an asylum case before, you're interviewing, you're developing facts, you're drafting affidavits. It takes, trip after trip after trip to work through that with your clients. You have to gather other evidence, do research with your client. I have spent upwards of 20, 30, 50 hours in preparation for an asylum case. And so you certainly, having your client be behind bars and having no access to her would make it necessarily almost impossible to properly prepare her. And if she didn't have counsel at all, you can only imagine what that would mean. And then I already talked about the conditions. So obviously, all of these raise for us serious concerns about the fairness of the procedure that a survivor being held in a detention center would encounter. Another issue really is that the orders call for the expediting of claims at the border. Now this is hard because I've just said to you that I don't like the idea of applicants coming across the border being held in detention for a long time. The opposite side would be, well, why don't you do their cases more quickly, and then maybe they won't have to stay in detention for very long. Well, my response, often when I get that question is for exactly the same reasons. If you rush an asylum case, that is complex and that involves a lot of legal issues, the chances that that case will be properly put in front of the judge and will have adequate representation and adequate legal preparation are very minimal, and the likelihood of success goes further down, even if the client fully merits protection under the law. Go ahead, Kristen.
And also, Archie, we know that particularly with trauma survivors, they're often unable to really tell their story or disclose all of the relevant facts until they've had an opportunity to stabilize their life and perhaps get some mental health counseling, and that becomes all the more difficult or impossible if they are detained and on an expedited docket.
I think that's absolutely right. Thank you for raising that. Okay, so let me move along from the border. Now I realize we're zipping through these very complicated concerns that we have, but still I think we'll cover this and move on to the practical pieces. So the next slide is about starving the system, which is my way of saying that the overemphasis I think these orders have on enforcement, deportation, deterrence, detention, really is going to drive a lot of the funding, a lot of the attention, and a lot of the resources, human resources, away from a system that is already here to help us figure out who qualifies for protection under the law, and is instead going to be turned in a very different direction. So what I expect we're going to see is that backlogs that we already have around the country, clients around in our offices anyway are facing wait times for immigration court of up to 5 years, I believe, are the dates now. If clients are waiting right now for 5 years and the orders demand that all immigration judges and asylum officers be diverted to the southern border, then who is going to take over and respond to those cases that are currently pending? It could be much longer than 5 years in that situation. So we're obviously very concerned about that. And the orders do not call for additional hiring of judges and officers, or in fact any other affirmative officers to be able to process cases. The orders do call, my third bullet point here, for building a wall, banning individuals, requires many different reviews of existing processes, asks for studies to be made and reports to be made to the president. So there's a lot of additional workload that's contained in these orders. When I first read it, I thought, oh my gosh, how are they going to do anything over there in the federal government relating to immigration for the next several years? They're going to be buried in paperwork. And so I have a real concern about what this will mean. Now, the last bullet I have here relates to requiring interviews. There is it's a little tiny bullet point at the bottom of a page on one of the orders that has not yet gotten any attention as far as I've seen, which says that nobody will be allowed to waive the interview process for a visa anymore. And that has raised concerns for us in terms of whether VAWA applicants and others, U visa applicants, be required in the future to undergo interviews. That certainly would be a huge drain on resources, number one, but obviously as concerned advocates for women who've survived gender-based violence, we're also very concerned about the re-traumatizing impact of interviewing clients. As attorneys, we know that when we question our clients, we sometimes send them away from our offices feeling worse than when they came to us. And I think forcing clients to go in front of officers to interview for VAWA and U visa applicants would be hugely concerning. Kirsten's raising a question.
Archie, while we're on the point of VAWA and U visa applicants, we do have a question about whether you can clarify whether VAWA confidentiality in the Privacy Act application to non-citizens, particularly in U visa VAWA applicants' context, will be affected by these, and also what do we know about whether U visa and VAWA petitions that are filed with the Vermont Service Center being perhaps forwarded to immigration court after an adverse decision?
Okay, both very good questions. Let me take the Privacy Act question first. So there is, in one of the orders, there is a sort of requirement to stop honoring the Privacy Act, essentially for immigrants. And so the VAWA confidentiality provisions we hope will trump that, I should say supersede that, and make possible make possible an exception essentially to be made. I mean, obviously we would like the Privacy Act to apply to all those who are going through immigration proceedings, but certainly we do need the VAWA confidentiality provisions to prevail. At this moment, we are just we've been asking in the administration and among our friends in the agencies whether they think anything will happen to that. I mean, thankfully, the VAWA confidentiality provisions are statutory, and we don't have a sense right now that they can be simply brushed to the side by an executive order like this. This may very well be an issue for litigation for us going forward. It is the kind of point where if there is an executive order that disagrees with the statute, we may need to get that resolved through a legal process. But right now we don't have an indication that the VAWA confidentiality provisions will be completely ignored. And I think we have to move forward on the assumption that they will stay intact for now. The other question was about referrals, and honestly, we don't have an answer to that either. Some of us in the advocacy community are very convinced that that is a likely possibility, that when, if somebody's VAWA application were to fail right now, there is no real consequence, but that down the road it could become possible that a failed VAWA application, much like a failed affirmative asylum application, could become fodder for a removal proceeding, a notice to appear in removal proceedings sent over to the courts. If that does happen, if that does happen, obviously, how we advise our clients in proceeding with their cases will change dramatically. As of now, that is an area where I think significant additional infrastructure and resources would have to be put into place to, first of all, to have the immigration courts absorb the volume that might be created, as well as to create the pathways for that and to create the staffing. So I don't think it's going to be an overnight problem, but it is certainly a problem that is within the, it seems to me to be within the legal jurisdiction of the executive branch to indicate that something like a change like that might happen. And so we are very watchful, and we are hoping that that will not be the case. I'm going to move on to banning certain people from entering. The next slide. And so as you'll see in the next slide, this is where I've addressed the orders that have gotten the most attention, mostly because I didn't want to spend too much time on this, since there has been a lot of information out there. Tahirih has a series of Facebook Live videos on our Facebook page, as well as, and those have been turned into YouTube videos. You can also read some of our advocacy online, and many other organizations are also speaking out about this. But certainly you all probably know by now there has been a ban put into place through the executive orders on entrance from 7 countries, which means getting visas of any kind and coming into the United States from 7 countries. As soon as it was issued, mass chaos ensued. The airports were crowded with families concerned about loved ones who were stranded overseas, as well as many of us attorneys who flocked to the airports and were hoping to be helpful in this situation. We tried also to speak with Customs and Border Protection officers on the ground. They also were very confused. As a result of this very confusing and plainly discriminatory ban, lawsuits have been filed around the country. As you know, the lawsuit filed by the state of Washington, joined by the state of Minnesota, in Washington, in the federal court in Washington, has resulted in an emergency TRO, temporary restraining order, which then was appealed by the federal government, Department of Justice, to the 9th Circuit, and just I think it was 2 nights ago now. Was it last night or 2 nights ago? I can't even remember. It was last night. 2 nights ago?
Last night, yeah.
We're all confused. Things are moving so fast here. I'm sorry, but just recently, no, it was last night, the 9th Circuit upheld in a 3-0 decision to uphold that temporary restraining order. And so there is actually, I know it's last night because Layli, our executive director, our CEO, was online last night on Facebook Live at 10 o'clock explaining the 9th Circuit decision, in case you're interested in checking that out. The initial ban was for 90 days. We really don't know what's going to happen to that timeline, and we do assume that this is going to continue up to the Supreme Court. For now, it is business as usual. Customs and Border Protection and Citizenship and Immigration Services who process cases, as well as the State Department who issues visas, they have all said that it's business as usual for now. The temporary restraining order has restored everything to how it was. So if you have clients who are from these 7 countries and find themselves overseas, we have been advising that people take advantage of this window and do return to the country right now, return to the United States right now, and that any other clients be advised not to leave, because we don't know when this ban could go back into effect. We do think additional countries could be added, and so we will be watching carefully for that. We also know that there was a complete halt to the refugee processing, U.S. refugee processing system and resettlement for the next 120 days, including those who had gone through the extremely difficult and long process of having their refugee claims processed overseas. Only 1% of those who seek refugee processing even make it to their first interview and with the United States government, and they have 3 interviews and multiple checks and screenings, and all of that was even revamped and made more strenuous in 2011. And so people who have gone through that for now in a process that could take 2 years or more have been halted and left outside the country. Now, now that the ban is lifted, some of that is alleviating. The 50,000 refugees, the ban limits the numbers of refugees that will come to this country to 50,000. Honestly, the fiscal year begins before the calendar year. It begins in October, and so actually, you know, we were about halfway through to that number already when the ban went into place. So hopefully we'll get to that 50,000 soon. And there's been a complete ban of Syrian refugees that's indefinite and simply purely based on national origin with not very much room for any kind of exceptions to be made. So just really quickly, and then I want to hand it over to Kirsten, who I know is actively answering your questions as we go online and also raising them orally, but let's turn it over to her. I just wanted to mention that we are at Tahirih, just so you know, we are engaged in a lot of advocacy here, both at the executive level with the agencies. We're learning what they're planning. We're actively going to DC, listening to the, attending the meetings, being present, you know, making sure that they know what our concerns are, and lobbying as much as we can. We're also participating in litigation. We have been filing amicus briefs and are going to be primary litigants in a couple of suits as well, and we're beefing up our capacity to use litigation. We haven't historically been a big impact litigation shop, but we are now about to move into that direction for the next couple of years, anticipating that this is going to be a very important way to preserve some of the huge gains that have been made, especially in the gender asylum area, but certainly in a number of other areas such as Privacy Act that was raised earlier. And also in making sure that our local police officers can protect survivors of violence in their homes. Another thing we're doing is working with Congress. Now, you may have seen a number of bills come up in Congress, some of which seek to codify some of the pieces of the executive orders, and other bills that seek to condemn pieces of the orders. And so we're working. Tahirih is a nonpartisan organization. We do not align as Democratic, Republican, or anything else. So we are working with our allies and partners on both sides of the aisle to make sure that we are educating members and that we are at the forefront of any bills that we think would be helpful to survivors and our clients across the country. Education and media advocacy are also cornerstones of our current strategy, and we would love to hear from you in your capacity as a pro bono attorney or in your capacity as a citizen or just a member of our society. If you would like to engage with us and take action with us, we welcome you. We are all here because we're concerned about women and girls who've suffered gender violence and are not being afforded their rights as they should under the law. And so we welcome you as our partners. Let me turn it over now to Kirsten to talk more about some of the practical concerns for you as attorneys who are helping our clients.
Great, thanks Archie. As Archie mentioned and explained quite eloquently, there's frankly a lot that we don't know right now and a lot of unanswered questions, and we know that makes it very difficult on figuring out how to advise or counsel clients. But the next few minutes we'd like to talk about some things that we do know or some best practices that you can take now that, regardless of how the policies and guidance and procedures shake out over the next several months and years, protects to the extent possible your clients as you're working with them. And I'd really like to start with reaching out to your clients. We are hearing from most of our clients. Our phones are ringing heavily here at Tahirih, so we really encourage you to reach out to your clients proactively to provide support and solidarity and good information, even if it's limited. Your clients are hearing all sorts of things from all sorts of sources, and so even if the information that you have is limited and does not answer every question they have, they trust you, and it's good for them to hear what we do know to be true and what we don't know yet from you, and not from unreliable sources or notarios who will pop up out and make unkeepable promises and take advantage of our clients and their family members. We encourage you to advise your clients regarding their rights when dealing with law enforcement and immigration enforcement. At Tahirih, many of our local offices are engaging in significant community outreach for Know Your Rights information, and we are happy to get that information to you as well to let your clients know. We've gotten a lot of questions on the chat about what to do with clients who may have criminal histories or may be at risk of traffic stops or other things, and whether that will make them deportable or a priority. And given the vagueness of the executive orders, we can only assume or prepare for a broad and vast sweep up or interpretation that almost anything could count against your client. So it is important to advise your clients to avoid adverse interaction with law enforcement to the extent possible. If your clients have children who are derivatives on their claims, that's incredibly important. In some jurisdictions, particularly here in Virginia, we do see a lot of challenges with teenage derivative clients getting stopped by law enforcement or school resource officers. And while historically those juvenile delinquency issues haven't always been a problem for their immigration claims, we don't know that we can be so secure in those, confident in that moving forward. A lot of great questions about whether clients should be advised from the 7 banned countries or from any countries, whether we should advise them not to drive. At your firms and on your cases, we strongly encourage you, if possible, to consider arranging transportation for your clients to get to your office or going to them. Certainly check in with your Tahirih mentor attorneys, because different areas of the country and different counties are different. Speaking from the perspective of Northern Virginia, there are some parts of our jurisdiction where driving is one of the most dangerous things that an undocumented client or a client without stable immigration status can do, and can get them really swept up into these expanded priorities. So to the extent that your firm covers resources such as sending a taxi or an Uber, that's a great way to help keep your clients safe as you're working on those asylum claims. Or as you're working on those claims, we encourage you to use caution, ask questions of your Tahirih mentor attorney if you're worried about filing. But as Archie mentioned, right now there is a lot unknown, and it's business as usual to the extent that we know in terms of filing claims, whether they're VAWAs, Ps, Us, or asylum claims. So we encourage you to move forward with working on those claims and raising any concerns that you have with your Tahirih mentor attorney to suss them out on a one-on-one basis. And we also encourage you to file as expediently as possible. Right now what we are hearing is that nothing drastic has necessarily changed yet at the Vermont Service Center or at certain local offices, and so it's in your client's best interest to get a viable claim filed now rather than in 6 months when things might have changed. So continue to work hard, as we know you all are doing, to get those claims filed. Another way to consider helping your clients stay safe is to use your firm's address as a safe address on all forms that are filed affirmatively with immigration, essentially masking your client's address, particularly if they have prior removal orders or criminal history or anything that would flag them as being at particular risk of immigration enforcement under the executive orders. Please consider using your firm's address. And also consider how you're approaching your filing fee applications when you are preparing filings that do have filing fees. There's a lot we don't know yet about the application of language around public charge and use of public benefits, making clients or immigrants more vulnerable to removal. But definitely check in with your Tahirih mentor attorney if you've got concerns about how you're preparing those fee waivers, so that you're erring on the side of disclosing what needs to be disclosed and perhaps not more than necessary on those disclosures about any public benefit use. Also, in the vein of filing quickly as possible where you're in immigration court, or try to seek to expedite hearings where it is possible. We know it's incredibly difficult to get hearings expedited right now, but to the extent that it's possible to get merits hearings expedited or asylum interviews expedited, we would encourage you to do that as well. So that's really the tips and practical concerns that we have at this point in terms of how to approach your cases, and how to talk to your Tahirih clients. But I did want to take a moment and also talk about safety planning with your clients. As attorneys, your clients have a lot of trust in you, and they value what you can help them with. And so safety planning can be a really important process. And we talk about safety planning a lot in this work about how to safety plan for an incident of abuse. But safety planning around the risks generated by immigration and the police themselves is incredibly important for survivors. So as mentioned on the slide, helping your client and encouraging them to collect important documents and information, their financial records, identity documents, medical records, their children's school and birth certificates, and all of that stuff. If you think about if you had to pick up one day and you didn't have access to anything at your home office or your lockbox anywhere, what would you wish you had access to? Those are the things we want our clients to be collecting and putting in a safe place, and figuring out who in their family or trusted network is the go-to person to get that stuff and to get it to the people that need it to help them get out of detention or help them plan if they do end up being removed. They should be carrying around your name as their attorney, their Tahirih attorney's name. If they're working with a domestic violence advocate or a social worker, they should be carrying that around as well, or memorizing it so that they can contact immediately somebody who can help them launch into action. Because one of the most difficult things if you are stopped or swept up by immigration is the lack of access to help and the inability to really get in touch with people when you're in a detention center or a jail cell somewhere. They should know their alien registration number, that A number, 9-digit A number, for themselves and any children who are included in their cases. And they should try to have that memorized so that if they need to talk to somebody, they know it off the bat. And then, Archie mentioned this earlier, but travel is really a concern here. Certainly, if your clients are from one of the 7 affected countries from the January 27th executive order and they're in the country now, they should not leave if they don't. But that should also apply to anybody really who is not a citizen or who's a dual citizen. I think this is a time that we need to seriously consider the risks of return for travel for anyone. As we saw on January 27th, chaos ensued immediately, and even a client who otherwise doesn't seem to have any risks associated with travel, now is probably not the best time to travel. If they can avoid traveling, they should try to stay put. And we know that's difficult to ask of clients, but if they do feel like they absolutely must need to travel, they should talk to you as their attorney, their Tahirih attorney as well. Everybody should know the details of the travel and be advised of the risks of the travel and have a plan in action if they encounter difficulties returning. We got several questions, and Archie also mentioned this earlier, about whether or not to call 911. I think it's a huge question, and it's a huge unanswered question right now for survivors. And the best answer we can give you is the best resource for that question on your cases is your Tahirih mentor attorney. I know that in our local offices we have a close ear to the ground and close working relationships with community-based organizations and often law enforcement victim services advocates in a variety of jurisdictions. And some jurisdictions right now, I would advise a client absolutely still call 911. And there are frankly some law enforcement agencies right now that I would say don't do it unless it's a life or death emergency, because we can't trust that that law enforcement agency won't arrest you instead. And so your Tahirih mentor attorney is the person best situated to help you determine whether calling 911 may be safe in your particular client's case. So we know that's not an ideal answer, and we wish that we could say across the board still that survivors should feel safe and comfortable calling 911 when they're the victims, but unfortunately we can't guarantee that in every jurisdiction in the country. We also encourage you to share Know Your Rights materials about what to do when your clients interact with law enforcement, or with immigration, particularly their rights in terms of answering the door, speaking to immigration without counsel. We have a lot of materials on Know Your Rights, and so if you need those, contact your Tahirih mentor attorney, and we will get that information and those talking points to you as well. And then finally, I think we just would want to reiterate that any travel abroad is very unadvisable at this time. So talk to your clients very seriously about the potential consequences of travel. And just be frank with your clients that there's a lot that we don't know right now, and we don't have answers for every question. But it's important that they maintain communication with us and that we maintain communication with them as things are changing rapidly, so that they feel safe and comfortable coming to us before they do take any action that may adversely affect their safety in the United States. And we would extend that as well to you as Tahirih attorneys, that please feel comfortable and safe coming to us with questions as they arise, because things are changing so rapidly that we will get you the best information and analysis on a particular case question as we have it in these ever-changing times.
Okay, so just to wrap it up, I would just add, again, we certainly welcome you to contact us. We'd love for you to take a case with us if you are interested, if you already have a case or you know friends who need a case. You think, you know, they've been, many of us have friends at our workplaces that are saying, what do I do? What can I do? How can I help? We have needs at Tahirih. We have a lot of clients who need us. And we have additional people who are calling us. We are trying to expand the services we can offer our clients. So previously at Tahirih, for example, we would have, in some of our offices, we had restricted hours of phone answering to be able to screen clients for new cases. We have now expanded. In all 4 of our offices, we are answering the phones from 9 to 5, Monday through Friday, to be able to, you know, provide that kind of, to answer questions and provide service to anybody who calls us and needs that help. You know, we need support in order to make that happen, both through pro bono assistance and through your donations. We also need assistance with advocacy, research writing, impact litigation, and you know, advocacy support, even if it is like tweeting and calling your Congress people. Again, I said earlier that we're all in this together, given the fact that we are fighting for the same clients. And so we welcome your support in whatever way you can offer it. So with that, I think with no other questions having come in these last few minutes, we'll go ahead and wrap up for today. I want to say a huge thank you to you for your time. We'll post this in our pro bono library, which you have access to. And if you would like if you have any questions or need any other information, please don't hesitate to contact your Tahirih supervising attorney, and we will get whatever information we can to you and to your clients as quickly as possible. Thank you so much.